The average American family pays between $15,000 and $35,000 to transfer assets after someone dies. Court fees, attorney fees, months of waiting. All of it completely avoidable. There is one document that eliminates every single one of those costs. Most Americans don't have it, not because it's complicated, not because it's expensive, because nobody ever explained it clearly. In this video, I'm going to give you the plain language explanation. Most lawyers charge $400 an hour to provide. What a living trust is, how it works, what it costs, what goes inside it, and the one mistake that makes the whole thing completely useless, even when people have one. By the end of this video, you will understand living trusts better than most Americans who have already paid an attorney to set one up. What a living trust actually is. Let's start with the simplest possible definition. A living trust, also called a revocable live-in trust, is a legal structure that holds your assets during your lifetime and transfers them directly to your beneficiaries when you die. Without a court, without a judge, without probate. Here's how it works in plain language. You create a document, the trust agreement, that establishes a new legal entity. That entity is your trust. You give it a name, typically something like the John Smith Living Trust, dated January 1, 2026. Then you transfer ownership of your assets into the trust. Your home, your bank accounts, your investments. The title on these assets changes from your name to the name of your trust. But here's what most people don't realize, and this is the part lawyers often skip. You don't lose control of anything. When you set up a living trust, you serve three roles simultaneously. You are the grantor, the person who creates the trust. You are the trustee, the person who manages it. And you are the beneficiary, the person who benefits from it during your lifetime. In practice, nothing changes day to day. You still live in your house. You still spend money from your accounts. You can buy and sell assets inside the trust whenever you want. You can change the trust. You can update the beneficiaries. You can even dissolve it entirely. That's what the word revocable means. The trust is yours, completely, for as long as you're alive. The difference only becomes visible when you die. At that point, instead of your assets going through probate court, your successor trustee, the person you named to take over, steps in immediately. No court filing. No judge. No waiting period. Your successor trustee distributes your assets according to your instructions, privately, quickly, and completely outside the legal system. That is what a living trust does. It replaces the court with a person you trust. The 5 things a living trust does that a will cannot. Now let's get specific, because a lot of people think a will and a living trust are basically the same thing. They're not. Here are the 5 things a living trust does that a will simply cannot. Number 1, it avoids probate entirely. A will is a roadmap through probate. A living trust is a detour around it. When you die with a will, your family goes to court. When you die with a properly funded living trust, your family doesn't. The average probate case in America takes 9 to 18 months. A living trust distributes assets in days, sometimes hours. A couple in Arizona set up a living trust in 2021. The husband passed away 2 years later. Their daughter, named a successor trustee, had full access to all accounts in their home within 4 days of her father's death. No attorney, no court date, no waiting. 4 days. Number 2, it keeps your affairs private. When a will goes through probate, it becomes a public document. Anyone can read it. Your assets, your debts, who you left money to, how much, all public record. A living trust is completely private. Nobody outside your family ever sees it. For families with business interests, real estate, or simply a desire for dignity in death, this privacy is invaluable. Number 3, it protects you during incapacity, not just at death. This is the benefit most people don't know about. If you become unable to manage your finances due to illness, injury, or cognitive decline, your successor trustee steps in immediately and manages your trust assets on your behalf. No court-appointed conservatorship, no legal battle, no delay. Your chosen person takes over, exactly as you planned. A will provides zero protection here. It only activates at death. Number 4, it reduces family conflict. A properly drafted living trust leaves almost no room for dispute. The instructions are specific, legally binding, and private. There's no public probate process where distant relatives or creditors can challenge the distribution. For blended families, second marriages, or any situation where family dynamics are complicated, a living trust provides clarity that a will often cannot. Number 5, it works across state lines. If you own property in more than one state, say a home in Florida and a vacation property in North Carolina, a will requires probate in every state where you own property. That means 2 separate probate processes, 2 sets of attorneys, 2 sets of fees. A living trust handles all of it in one document, regardless of how many states are involved. What goes inside a living trust and what doesn't? This is where most people make expensive mistakes. Not everything belongs in a living trust, and some assets should never go in. What you should put in your trust, your home, and any real estate you own. These are the most important assets to fund into the trust, especially if you live in California, Florida, or New York, where real estate going through probate triggers the highest costs. Bank accounts and investment accounts. Contact your bank and brokerage and ask to retitle the accounts in the name of your trust. Most institutions have a simple form for this. It takes 20 minutes. Business interests, if you own a business. Sole proprietorships and partnerships can generally be transferred into a trust. The process varies, so consult your attorney for this one specifically. Personal property of significant value, jewelry, art, collectibles. These don't have titles, so you transfer them with a written assignment document that lists the items and states they are now owned by the trust. What should not go in your trust? Retiring accounts, IRAs, 401ks, 403(b)(bs. Never transfer a retirement account into a living trust. It would be treated as a withdrawal by the IRS, triggering immediate taxes and potential penalties. Instead, name your trust as the beneficiary of your retirement accounts, if that's your goal, or simply name individuals directly. Health savings accounts and medical savings accounts, same rule applies. These accounts have specific tax advantages that are lost if transferred into a trust. Vehicles, in most cases, not worth the administrative effort. Use a transfer on death designation if your state offers it, or simply let them pass through the estate. Life insurance. Your trust can be named as the beneficiary of your life insurance policy, which can be useful for distributing proceeds according to your trust instructions, but the policy itself doesn't go in the trust. The key thing to understand, a living trust only controls what's in it. Assets left outside the trust that don't have beneficiary designations still go through probate. This brings us to the single most important concept in this entire video. The funding mistake that makes everything useless. This is the most important part of this video, and it's the part most attorneys don't explain clearly enough. Setting up a living trust is only half the job. You must fund it. Funding means transferring your assets into the trust, change in titles, updating deeds, contacting your bank, retitling your investment accounts. Until you do this, your trust is an empty container. A beautifully drafted, legally perfect, completely useless empty container. Here is a real example of what happens when this step is skipped. A man in Texas paid $2,800 for a living trust package in 2019. He signed the documents, felt good about it, and went back to his life. He passed away in 2024. His daughter, named as successor trustee, contacted the bank to access the accounts. The accounts were still in his name, not the trust's name, his name. Because he never funded the trust, never changed the titles, the bank treated the accounts as a regular estate. They were frozen. His daughter had to file with the Texas Probate Court. The process took 8 months and cost $11,000 in fees. He had a living trust. It didn't help him at all. This is not rare. Unfunded or partially funded trusts are one of the most common problems estate planning attorneys encounter. People set up the trust, pay the attorney, feel protected, and then never complete the funding process. Here's what funding actually looks like in practice. For your home, your attorney prepares a new deed transferring the property into the trust's name. The deed is recorded with the county. This typically costs $200 to $400, including recording fees. For bank accounts, you visit your bank, show them the trust document, and complete a retitling form. Most banks handle this at the branch level. It takes 20 to 30 minutes. For investment and brokerage accounts, contact your brokerage by phone or online and request a beneficiary or ownership change to the trust. Most major brokerages have a standard process for this. Funding is not a one-time task. Every time you open a new account, buy a new property, or acquire a significant asset, you need to bring it into the trust. The trust only protects what it owns. What it costs and how to get started. Let's talk about money, because cost is the most common reason people delay. A living trust prepared by an attorney costs between $1,500 and $3,500 for a standard revocable trust nationwide. In California, costs run higher, typically $3,000 to $5,000, given the state's complex property laws. In New York, expect $1,000 to $3,000 for a basic trust, plus county filing fees when transferring real estate. Online platforms like Trust and Will and LegalZoom offer living trust packages starting around $400 to $600. These are appropriate for straightforward estates: a primary residence, standard bank accounts, no business interests, no complex family situations. For more complex situations, multiple properties, business interests, blended families, or significant assets, an attorney is worth the additional cost. The trust needs to be tailored to your specific situation. Here's the math that makes this simple. A living trust costs $400 to $600 online, or $1,500 to $3,500 with an attorney. The average probate costs 3% to 7% of your estate value. On a $300,000 estate, a home, retirement savings, and a bank account, probate could cost your family $9,000 to $21,000. On a $500,000 estate, that's $15,000 to $35,000. The math is simple. The cost of a living trust is fixed. The cost of probate is not, and your family pays it at the worst possible moment. Let me bring this together. A living trust is not a complicated legal instrument for wealthy families. It is a practical tool for anyone who owns a home, has bank accounts, and wants their family to avoid the cost, delay, and public exposure of probate. It avoids probate entirely. It protects your privacy. It works during incapacity, not just at death. It handles property across multiple states, and it distributes your assets in days, not months. The cost, between $400 and $3,500 depending on complexity, is a fraction of what probate will take from your family if you don't have one. The one thing that makes it useless, not funding it. If you have a living trust right now and you haven't verified that your home and accounts are titled in the trust's name, that is the single most important thing you can do today. But a living trust is not perfect. In the next video, I'm going to walk through the 7 disadvantages of putting your home in a living trust, things most estate planning guides never mention. If you already have a trust, or you're about to set one up, the next video is something you need to watch before you sign anything. I'll see you there. If you found this video useful, don't forget to hit like and subscribe. It helps more families find this information.